Mr. Chair, honorable colleagues, I am presenting SB, I'm not fond of the number, 666. Not a good way to start. Last year, through the budget process, the legislature enacted the Mental Health Diversion Program through AB 1810. However, the program was overly broad and contained many flaws. In order to rectify that, the legislature passed a follow-up measure, SB 215, which included many fixes and received near unanimous support. SB 215 stated that those who are charged with several very serious crimes, such as murder and rape, should be excluded from eligibility for the mental health diversion program. However, in consultation with prosecutors from my district in Riverside County, it is clear that SB 215 did not go far enough. There are still several very dangerous crimes still left open for potential diversion. My bill closes that loophole by adding armed robbery, assault with a deadly weapon, child abuse, elder abuse to the list of ineligible crimes for mental health diversion. These are very serious and dangerous crimes, and those accused of such crimes should stand trial and not be diverted to a mental health program to escape potential punishment. For those reasons, I respectfully ask for your vote.
Do we have any other witnesses in support?
Tiffany Matthews on behalf of the California District Attorneys Association in support.
Any other witnesses in support? Any witnesses in opposition?
Good afternoon, members. Micah Doctoroff on behalf of the ACLU of California, here in respectful opposition to this bill. While we appreciate the author's goal of protecting public safety, we do not believe SB 666 is necessary to further that purpose. Importantly, existing law provides that mental health diversion will be granted only if, after considering the opinions of the district attorney, the defense, or a qualified mental health expert, as well as the defendant's violence and criminal history, the current charged offense, and any other factors that the court deems appropriate, the court is, quote, satisfied that the defendant will not pose an unreasonable risk of danger to public safety if treated in the community, end quote. This is all to say that under current law, a person charged with any of the offenses named in SB 666 would only be granted diversion if their treatment in the community would not jeopardize public safety. There is no indication that judges cannot effectively weigh the relevant factors and appropriately use their judgment to determine who should and who should not be granted diversion. A blanket exclusion for specific charges is therefore unnecessary. For these reasons, we respectfully oppose the bill. Thank you.
Thank you, Ms. Doctoroff.
Leslie Caldwell, California Public Defenders Association. SB 666 seeks to remove offenses from the list of charges that may be considered by the court for mental health diversion. Therefore, under 666, even if the court concludes that a victim, defendant, and community would benefit from this court-supervised diversion and treatment, the court would be powerless to order it. Roughly a third of the inmates in California jails suffer from serious mental illness. Too often untreated mental illness is the reason these individuals are involved with law enforcement in the first place. The vast over-criminalization of the mentally ill, coupled with the dearth of services for the mentally ill, has led to jail and prison overcrowding, repeated and costly lawsuits, and the warehousing of the mentally ill persons in facilities that were not designed to treat them. We heard earlier testimony about Los Angeles County being the largest mental health institution in the nation. It competes only with Cook County Jail. I talked to the Solano County Sheriff yesterday, asking him what percentage of his jail population was on psychotropic medication. He said 24% of his jail population is on psychotropic or other mental health medications, and that doesn't include the persons who need medication but refuse to take it. The sheriff in Solano, like most sheriffs, refuses to force medication. In June of 2018, Governor Brown and the legislature took steps to address the problem of our prisons and jails turning into makeshift mental health facilities. Penal Code Section 1001.36. This section allows, but does not require, trial courts to divert mentally ill defendants into pre-existing treatment programs, where the proposed treatment program is consistent with the needs of the defendant and the safety of the community. By allowing this early diversion, the mentally ill, the community is protected by reducing recidivism rates for mentally ill defendants and avoids the unnecessary and unproductive costs of trial and incarceration. I would like to share a couple of examples of success by even seriously mentally ill and very violent offenders who went into Veterans Court, a very successful diversion program. Albert C. was a veteran of the Iraq War. He was originally charged with attempted murder. He was in a full psychosis due to his PTSD that came from his tour of duty in Iraq, and believed his roommate was attacking him. He repeatedly stabbed the roommate and stopped when he finally heard his roommate screaming, "You're killing me." He called for emergency services for his roommate and turned himself into the police. He was, after great discussion, admitted into the Veterans Court. There was a great discussion between the court, the DA, the defense, and the service providers, a very robust discussion. He was placed into the program. He graduated from the Veterans Court program, having no violations and no sanctions, which means he did everything absolutely right. He remains in counseling and on medication and is a successful member of our society today. Joseph R. was charged with assault with a deadly weapon and spousal abuse. During the incident, he ultimately recognized the danger of his actions, unloaded his gun, and turned himself into the police. As he worked through Veterans Court, he realized the seriousness of his mental illness and substance abuse problems. He too graduated from Veterans Court with no sanctions, no violations, and is a very productive member of our community. I could give examples of how much diversion can help those who have committed serious crimes and turn their lives around, thus protecting the safety of the community. So to be clear, CPDA does not believe that every person that commits one of these crimes is suitable for mental health diversion. However, as workers on the front lines of the criminal justice system, we also know that a rule preventing a neutral judge from considering the individual before them, the facts of each case, and the community is a tremendous step backwards on the road to meaningful criminal justice reform and mental health system reform. We respectfully request your no vote on SB 666.
Thank you, Ms. Caldwell.
Sorry,
Any
go
other
on.
witnesses in opposition? Any questions from my colleague? Okay. Would you like to make a motion then?
I'd like to make a motion.
And we have a motion. Senator Stone, would you like to make a
Yes,
closing
yes, I
comment?
would,
or-
Mr. Chairman. First of all, I appreciate the opposition and their viewpoints. I wish all the stories that the public defender described had a happy ending the way she says they do. By her own admission with the Solana Sheriff, 24% had issues, which means that 76% did not. We're not talking about trivial crimes. We're talking about very serious crimes. Assault with a deadly weapon, sexually abusing a child, sexually or financially abusing an adult. These are the list of ineligible crimes for mental diversion today, which I think are inappropriate. I'd rather err on the 75% that did these crimes with full mental capacity. These are the type of people that should be punished, and that's why I urge your support of SB 666. And thank you for the opportunity to be here. Urge your aye vote.